Today we have Sheila Millar, who is the outside counsel for the Toy Association, and she focuses on advertising and privacy. And we have Leigh Moyers, the senior manager of government affairs for the Toy Association, and they're going to discuss with us kind of the landscape of what's going on in the US as well as the EU around connected play and security.
Good afternoon, everyone. It's great to see you. We are with the Toy Association. Our association represents over 1,200 businesses that manufacture, businesses including manufacturers, importers, retailers, as well as toy inventors, designers, all the businesses involved in creating safe, fun, and educational toys for children. And I'm joined here by Sheila, and we are going to be talking about compliance. And we're both in DC, so you're going to get the lawyer policy wonk version of the presentation.
No
so
toys today.
No
toys in this session.
And just to give you a little bit more background, our association also does a lot of compliance webinars for our members so that they can understand the many, many regulations that go into product safety and privacy of toys. And I'm hoping Sheila can tell us a little bit more about all the agencies that regulate our industry.
Thanks, Leigh, and thanks everybody for sticking around for this session. It's true that compared to other categories, children's products are regulated more heavily than any other category. And within the category of children's products, toys are probably the most regulated sector, with juvenile products like baby monitors coming in there a close second. That means that there are a lot of agencies that you have to consider, not just at the federal level or international, but also state laws apply as well. And I think one of the things we want to do in this session is give you a sense of the pervasive regulatory structures that you have to think about if you're going to be marketing and selling connected toys.
Could you give us a brief overview of some of those main laws that govern connected toys in the US and EU?
Sure. So let's start with the US first. So we know, and we've talked all day about the importance of physical play and the connected product experience. So when we think about a connected product, what do we start with? There's something physical, right? So for the most part, even though you may have AR, VR types of experiences with AI embedded into it, we start with physical product safety. So for many years, toy safety has been regulated by the US Consumer Product Safety Commission. They adopted a law in 2008, which dramatically revised the requirements for products, children's products in general, and toy safety in particular. So in the US, you have to be testing toys to the ASTM F963 standard. It's a requirement of law, and that means you have to third-party test them using an accredited laboratory that's approved by the CPSC. You have to have tracking labels with your products, and there are a variety of obligations that go with that. From the EU perspective, we have a directive. A directive is not automatically enforceable as a regulation. We'll talk about the general data protection regulation in a minute. That means that product safety is regulated at the member state level. That's where the enforcement happens, and that means that there can be variation. But let's go back to the US. Let's not assume that the CPSC is the only thing we worry about. We have state laws that apply, and most particularly, we have green chemistry laws that apply. That requires reporting on the presence of chemicals, and as new chemicals in products generate concerns, the most recent example being fire retardants. Just at the end of the year, I believe, Massachusetts adopted a new law restricting fire retardants in upholstered furniture and carpeting and draperies. Guess what other product category is covered? Children's products. So for all of those products with electronics, that use fire retardants, think about what those implications are going to be for you. Prop 65, many of you have heard about Prop 65 in California, which is a chemical labeling law. So those are just a couple of examples that affect the physical product safety. On the privacy and data security side, which is an issue that we all at the Toy Association spend a lot of time on, we have no general privacy law in the US, unlike the General Data Protection Regulation in the EU, which applies to all products. But we do have the Children's Online Privacy Protection Act, which several panelists mentioned today. So we have a pervasive set of regulations here. In addition, just this past year, California adopted a new connected product law, SB 327, which will require certain security requirements in all connected products, not just connected toys. It's generally requiring reasonable security, but there are a few specific provisions, like if you are connecting outside a local area network, you either have to have unique hard-coded passwords on the device, or you have to have passwords that have to be changed before the first access by the consumer. So we're going to see more regulations addressing security for sure as we look ahead to 2019 and 2020. Also in California, we have the California Consumer Privacy Act, which is an attempt to mirror the GDPR in the US. And then in general, we look at the Federal Trade Commission. The Federal Trade Commission enforces COPPA, but it also has broad authority to address what's called unfair and deceptive acts and practices in commerce. That means false advertising, basically. And then again, just to keep it complicated, every single state has little FTC acts, and so states can enforce as well. So that's just a quick overview of some of the major laws that we have to worry about if you're making a connected toy.
Actually, could you maybe go back and highlight some of the differences between the GDPR and COPPA?
Sure. I think one of the principal differences is the GDPR is applicable to anybody, right? It's not specific to children's privacy. It applies to everything. COPPA has been in force for over 20 years. We had the 20th anniversary of COPPA this year. COPPA is a well-defined, well-recognized law. We all have over 20 years of experience of complying with COPPA. Not everybody does it perfectly, there are lapses, but we also have the benefit of enforcement actions by the Federal Trade Commission. State attorneys generals can enforce COPPA as well, and we've seen several examples of state enforcement as well. And we have a lot of guidance from the Federal Trade Commission. So for those of us who've been in the space for a long time, we know the FTC staff, we have dialogues with them frequently, although not now because the government is shut down. But we know them, we ask them questions, and that sometimes comes back in the form of guidance. For example, the FTC did an enforcement policy statement fairly recently, about a year or so ago, which addressed how to handle collection of voice data from children. So when they adopted revisions to the COPPA rule in 2013, that rule was a major change because it established that voice data is per se personal information. Collection of per se personal information requires verifiable parental consent. That's not the rule in GDPR. I'll come back to the GDPR in a second. But because there are very good experience with several companies that have already spoken today about how to manage voice data safely, the FTC said if you collect the voice data momentarily, transcribe it, drop it on the floor, delete it, so that you're answering a child's question or responding appropriately, they will not take enforcement action. And so while technically that is actually a violation of the law if you don't get verifiable parental consent, the FTC isn't going to enforce. So we think that there are ways that we can work with the FTC to address some of these common sense issues. So on the GDPR side, a lot of big differences between the GDPR and COPPA. The GDPR has one little provision on children, and basically the GDPR framework requires that you have a legal basis for processing anybody's data. So that could mean it's a government requirement, or that you have consent, or that you have a legitimate interest that's not outweighed by what they call in EU speak fundamental rights and freedoms of the data subject. And the legitimate interest concept actually provides, we think, a fair bit of flexibility for certain types of data collection that could mirror COPPA. When we look at the two legal instruments, I think it's fair to say that COPPA is more prescriptive. It's a lengthier set of requirements, but the concepts of privacy by design are really fundamental to both the GDPR and to COPPA. So a couple of quick differences. GDPR has a set of record-keeping obligations. You have to do privacy impact assessments or data protection impact assessments for higher risk level processing, for any type of processing. That's not required by COPPA. Although I would say that many of my clients who are doing that think it's a good idea to have that discipline of going through that formal analysis. Another difference is, as I mentioned, legitimate interest could be a legal grounds for processing. It's not at COPPA. COPPA has very specific things. You can do this without parental consent. You can do this with this type of parental consent. You can do this with notice. And these other suite of activities, you need verifiable parental consent. Enforcement is different. So COPPA is subject to the civil penalty structure of the Federal Trade Commission. It does not have anywhere close to 2% or 4% of global turnover, which is the astonishingly high civil penalty cap for the GDPR violations, although we've not seen anything coming close to that level. And I think the other difference is that there is still, we'll come up to the 1-year anniversary in May of the entry into force of the GDPR, and we still have very limited guidance on children's privacy. If, fortunately, for those of us who read English, you do have some guidance from the UK Information Commissioner's Office. There's also some guidance from the French CNIL for you French speakers out there. But there's still a lot of uncertainty about how we will match COPPA and the GDPR. And of course, the overriding big distinction is we operate solely on under 13 or kids in the US. In the EU, the GDPR establishes that a child is under 16 unless the member state establishes a different age, which can be no lower than 13. So we didn't bring our visual aid here, but we have a map that we've used that shows the different states. And that is going to create some compliance complexities because some of the data protection administrators, these are the member state regulators that enforce the GDPR, have suggested that requiring parental consent in a jurisdiction where actually the data subject is old enough to consent for itself would violate that child's privacy or that minor's privacy. So very much a state in flux in terms of the landscape.
And I know this year Congress has been taking a greater interest in the issues of privacy in general, not just children, but everybody's privacy. What do you think is ahead federally, and do you think COPPA is an important piece that they could be looking at as a basis?
So children's privacy always generates a lot of discussion and debate. What's been interesting around the 20th anniversary of COPPA is how the vast majority of the advocates, who tend to be highly critical, frankly, of the toy industry in general for anything that they can find, have been largely supportive of COPPA. So I think we're very comfortable from the toy industry perspective that COPPA has worked effectively. Are there things that we might tweak? Sure. I mean, one of the other differences between GDPR and COPPA is that GDPR covers any type of data collection. COPPA, as you all know, is strictly limited to the online collection of personal information from children under 13. And so will COPPA be expanded to cover offline data? Possibly, probably not such a big deal for CES. The piece that could create issues is mobile, right? So mobile is regulated by the Federal Communications Commission. It is excluded by COPPA, so mobile-to-mobile communications actually isn't covered by COPPA. But the trick is that if you're putting that data on the back end in a database that's online, then the FTC believes that it would be covered. And so, but if you can, maybe it would be easy if COPPA is modified so you could collect a mobile phone number, ask the child for that so you could text a parent, because parents are texting, and then notify them. We have then another problem, the Telephone Consumer Protection Act, which prohibits unsolicited text messages. So to the extent they want to revise COPPA and expand its reach, there are some other technical statutory things that would have to be worked out. I mentioned the California Consumer Privacy Act. That is triggering a lot of discussion in Congress about a federal privacy bill, because that legislation has some very restrictive elements in it that's causing a lot of consternation amongst industry.
Mm-hmm. And how has the Toy Association and the toy industry been involved in these policy conversations?
Yeah, so Leigh, as you well know, being on the policy side, the Toy Association has a very robust government affairs program. And so part of its objective is to advance its members' interests, to weigh in on policy issues. So for example, in 2010, when the COPPA rule was being modified, and there were a series of workshops at the Federal Trade Commission on that, I participated in the workshops on behalf of the industry. We submitted comments, and many of our comments were adopted. So one important example is the original proposed rule that was modifying COPPA that for the first time was establishing that device identifiers like IP addresses would be considered personal information. We looked at that and we said that's unworkable for our industry because it would mean when you hit the page or when you connect, you're going to have to get parental consent. And so that was changed, and that's why we have the support for internal operations exception in the COPPA rule today that many of you rely on as you're applying sort of good privacy by design principles and limiting data collection principles when you're working through your connected toy experiences. The other thing that we did is the original limitation would have only covered IP addresses that were used over time or across websites. That's effectively no benefit to the industry. So that rule language was changed to and, right? So you have to meet both structures in order to be covered. So that was a benefit to industry to allow them to continue to do analytics, to continue to allow kids to anonymously register with a username and password, save their game scores, have a little bit of a privacy-safe interactive experience. And so where we look is to find ways to innovate while keeping true to that privacy by design and data minimization concepts.
Yeah, and you mentioned some principles already, but I know that the association has kind of come up with 5 general guiding principles when it comes to connected toys, and I thought maybe you could elaborate a little bit more on those principles.
So the issue of security of data is also a significant issue for the U.S. Consumer Product Safety Commission. So again, in representing the Toy Association, we participated at a workshop that CPSC held in May on connected products in general to share the view of the Toy Association. So as compared to some other product sectors where you may have that same data is powering the device, is collecting personal information, so a data breach could have significant physical safety questions for a product. So for example, if you have your home toaster that can be remotely activated, and if there's a breach that affects the data and it could start a fire in the toaster, that's clearly a physical safety issue. So I think the Toy Association position is physical safety within the remit of CPSC, privacy and data security, information security is within the remit of the Federal Trade Commission. But we know that these questions about jurisdiction are coming up around the world. So There is something called the Product Safety Directive in the EU. There's a lot of debate about updating the Product Safety Directive in the next couple of years, and jurisdiction over the Internet of Things, over connected products, is very much on the mind of regulators.
It all sounds very complex.
Yes, it is.
Do you have any tips for compliance that you'd like to share?
Yeah, so I think that I found it interesting this morning with so many of the panelists talking about, I'm a parent, I have a daughter, I have a son. You know, I think that one of the key things is to think about connected toys from the perspective of the parent, right? How would I want my child to experience this product? I have yet to meet a client that comes to me and says, I want to make a cheap, unsafe toy that's going to hurt kids and violate their privacy. Nobody ever says that to me. I don't think there's anybody in this room that would take that position. What I do find is that there is confusion. So my first tip is put yourself in the shoes of the parent, look at your technology, look at your platform, look at your product from that standpoint. My second tip is understand the legal framework. It is actually pretty astonishing that even with the best intentions, clients don't understand. So I've had a couple of clients who've entered the market in the EU. They comply with the EU product safety law, EN 71, looking at privacy from the EU perspective, but that doesn't mean they're going to comply with the US. And that is because in some respects, COPPA can be more restrictive than even the GDPR. It doesn't have the paperwork, but there are differences. And so where do you want to go to market when, if you have to retool your entire product design because it fundamentally doesn't comply with the law in a particular jurisdiction that you want to enter, that's a really expensive undertaking. My third tip is similar in that vein, not just understand the jurisdiction that you want to enter, but understand the differences in the legal framework. We have a lot of international clients that we work with, and it's interesting to have discussions about how they're sometimes reluctant to enter the US market. Why is that? Anybody want to hazard a guess? Litigation. Exactly, litigation. So in the EU, we're seeing a lot of discussions about expanding class action rights, kind of being more like the US. But there are some key differences that mean the US environment will always be much more expensive. First, we have really an advocacy system here. Lawyers like myself are advocates for clients. We're not officers of the court. We don't have loser pay rules here. You have loser pay rules in many jurisdictions. Class action rights are often limited. And so when we look at the landscape of litigation risks, a lot of folks are very concerned about the level of penalties under the GDPR because they're pretty high. But the risk of litigation, even winnable litigation, because we have also liberal discovery rules, if you have a regulatory investigation, if you have a lawsuit, it's going to be very expensive to defend that. So doing it right by understanding the legal underpinnings that apply to your product, to your platform, to your activity can be a critical component of success. And then my fourth tip is really focus on the brand value, right? So similar to acting like you're a parent, thinking about it as being a parent, it's really about promoting and protecting your brand. For the toy industry, we're really very sensitive to reputational risks, both to companies and to industries, because any regulatory issue of concern, and we're seeing this now in the larger privacy debate, always focuses on kids. Why do we have stronger product safety laws adopted in 2008? Because there was a whole debate about toy safety and children's product safety. Why are we having continuing discussions about maybe a national privacy law? They're bringing in children's privacy and data security into the mix. Right now, if we look at Europe, we have a new discussion about another instrument, a security instrument in probably a directive, but possibly a regulation. But self-driving cars and children's toys are sort of the two top dangerous products. Now, I think we happen to believe that self-driving cars probably have a lot more risk than most children's toys, but they're being lumped together in the same vein. And so understanding that risk to your colleagues in your industry is critically important to maintaining that message that we want to advance for the toy industry of responsibility, caring, focus on play, focus on the play experience, and focus on providing value to kids and to their families.
Oh, those are great tips, very, very helpful. And also the Toy Association is always happy to be a resource for questions when it comes to this complex environment. And like you said, things are going to be changing in the laws in the next couple of years, and there's going to be a greater focus on this issue. So it's something that we are going to be monitoring very closely, and always happy to talk further with people. I always call Sheila my privacy law guru, so there's no question that she has not been able to answer for me. So.
And I think it's important to understand that for those 1,200 or so companies that are members of the Toy Association, the association historically has offered a lot of resources. We have COPPA compliance checklists. We've had, webinars and seminars and programs, both on the physical product safety, on privacy and data security. And Leigh alluded to the development of the 5 guiding principles for connected products. So safety, security, privacy and security by design, transparency with parents. These are all principles that the Toy Association stands behind and thinks are very important to maintain trust. Because if you're making products for the littlest among us, the children, you want that trust of parents, you want that generational trust, you want the kids to, when they grow up, to remember their fun experience with whatever their favorite toys were, so they want to share those toy experiences with their own kids. So we know that there are many, many toy products and properties that are now nostalgia brands and are actually really popular with 18 to 24-year-olds who remember that experience, and they might buy jewelry, Hello Kitty, for example, or other types of products because they remember that. And so there's a value in brand extension as well.
Great. I think we are almost out of time.
I don't know if we have time, Tonda, for some questions.
Yes, we have two questions.
So briefly, I think the question was, who's responsible for compliance? And the example was Facebook, right? We know that there's a significant portion of kids who sign up for Facebook accounts, and they simply lie about their age. So COPPA basically has 2 elements to it. If you have a product that is primarily directed to kids, which would be any toy, it's covered by COPPA. If you have a mixed audience property, it's covered if you have actual knowledge. And so the law does not require you to go back and do sort of a hard verification, although there are some good verification services that are available, to determine that you're actually dealing with a child. And as long as you don't have actual knowledge that you're dealing with a child and then ignore it, you're fine. The onus is on the what we call the operator, so the entity that collects the data. And so it's in the connected toy space. What's interesting is you may do the plastic, right? And you may be working with a technology partner, and you may have an agreement where all the data goes to the technology partner and not to the actual physical toy manufacturer. They're the operator for COPPA. They have the compliance burden. But remember, too, the COPPA is a strict liability statute. And so for those of you who are thinking about monetization strategies, ad tech, any element of behavioral advertising violates COPPA without parental consent. And frankly, we didn't talk about the e-privacy regulation in the EU, but it's another instrument. It's the cookie directive, for those of you familiar with that. It's being modified. Some of the regulators in the EU have taken a very hard stance that there has to be consent before you place any type of cookie or technology. The GDPR establishes that if consent is the legal basis of processing, then consent has to be provided by the parent. the person in legal authority over the minor. And so, again, think of that world. What is it going to mean to you? You won't be able to do analytics. You may not be able to offer even a basic experience if that goes into force. So it is a very complex environment that continues to evolve.
Much.
Sorry, we'll maybe come around to the back
sure.
for a little
Yeah,
bit.
if you don't mind.
Yeah,
If
so
you
if
don't
there
mind, that
are
would be
extra
great.
questions that we didn't have a chance to answer, we're happy to stick around for a few minutes.
It's one of the most important things that we're going to cover today, and thank you for looking at it from the lens of building for toys and the connected world. But we can take that to anywhere in any business that deals with personalization. We need the data, and it's the next step. Thank you.
Thank you.